Hello, everyone. My name is James. I'm an attorney, and I did this panel 2 years ago, and I've sort of modified the slides. One of the main differences is that the last time I did it was on Zoom, and I had a partner who was joining me. This is a little bit about me. I'm actually not originally from Richmond. I'm from Tennessee, but I came out to the University of Richmond for law school, and I've been trying to find more ways to get involved in the local community and get to, actually know what's in Richmond ever since graduation, especially. But I do business, immigration, and intellectual property. The immigration piece is because that's more the firm where I got hired, but the business and intellectual property, like copyright and trademarks, that was always my passion. I always wanted to work with artists, creators. And so I am now in this very interesting kind of hybrid position, but it means no 2 days are alike. So I'm a lawyer. We always have disclaimers, got to have the fine print somewhere. So I'm licensed to practice here, passed the bar in Virginia. I can talk about copyright law in a federal sense because it's federal law instead of state law. What that means is if anybody happens to have questions about something, maybe you are coming here from a different state and you're like, hey, I have a Twitch stream or I have something else, can I ask you about copyright law? The answer is generally yes, as long as it doesn't get into a state-specific issue, and then I might have to defer. So even right now, I'm from Tennessee, but I'm not technically licensed to practice in Tennessee. So I can't tell my family, I'm happy to not be able to tell my family legal advice, but yeah, so I always hook on that. Everything we're talking about is just going to be informational. So what we say is this isn't legal advice. Legal advice is somebody saying, hey, I got this cease and desist letter, what should I do? Me telling you what you should do requires circumstantial conversations. We have to get into, well, why'd you get the letter? Is there any truth to or substance to that cease and desist letter? And recommendations, all of that gets into legal advice, whereas this is just what's a copyright, what's a trademark, is playing or is including text from a book in my comic, something that could potentially be reproduction. That's kind of towing the line, maybe. But we can kind of get into information versus advice. And then I've just got some images here, and we could talk about fair use, but I'm using this all for educational purposes, not trying to infringe on any copyright. So I'm going to say that all of my images are being used for fair use. All right, so here's our rough roadmap. We're going to start with IP, because most people, when they think of comics, they think about copyrights and trademarks, your logos, your images, the text, and I'll briefly touch on patents, but that's not really my my area, or something that I think most people will have questions about. Then we'll kind of see what we can do for the other areas, like forming a business, some key contract provisions and employment provisions that might be relevant, and then just some practicalities versus theoretical conversations. Okay, so first of all, what are copyrights, trademarks, patents? Copyrights, most of the time you think about like art. It's a creative work of expression. That's one legal way to kind of condense the definition down. And so it's kind of a very broad thing. We have a lot of different media and content that can be copyrightable, like books. We've got the text can be a separate literary work in a comic, or the images, you could have those as separate stills and prints and things like that. So there are a lot of different ways that you can protect the art and content in your comics if you're somebody who's interested in, or if you currently are a comic artist. But either way, that's something that you can look into, and you could definitely talk to somebody like myself to figure out, hey, what all can I do to protect my art? Trademarks, we're talking about origin of source for goods or services. So like, I'm gonna get this jacket, and maybe I care who made it, maybe I don't. If I care, then I'm gonna wanna know who has their logo or the brand on it. If I care about more luxury end products, then logos, all of that stuff matters a lot. If I want to get a Spider-Man comic or something like that, then I'm gonna be looking probably for a Marvel and trying to find, is this a genuine comic, or is this like fan fiction, or, how can I tell based on any kind of logos or source material, who has made the product? And it gets really important when you're a business, because the reason why people are going to buy your stuff is because they know you and your brand. So if somebody starts making knockoff products and it starts dragging you through the mud, then that could be a problem. And trademark law is one of those areas where you can use that to not only protect yourself, but also just to set yourself apart. Patents, we're normally just talking about inventions. So if you're going to come up with a new stylus or graphic design or drawing art for the comics, or if you're going to come up with something else, then usually that's going to be a separate process. It's pretty expensive, it's pretty complicated, and for lawyers, you have to pass a separate bar exam, and usually it's going to require like a STEM background. So I don't have either of those. I did work with a patent attorney, and I can answer some very, very basic questions, but I've been working at my current firm for like 4 years almost. So not really my area. That's just my way of saying that. Okay, so copyrights. On top of what I've already said, I've got the code section that describes what it looks like. Feel free to read that. It's a lot of words. The words that are underlined are some of the things that kind of differentiate significant terms for defining copyright. So like, is the work original? This is where we get into the whole, is it transformative? Is it unique? Did I come up with my own Mickey Mouse, or am I drawing, another Disney Mickey Mouse? If it's the same thing, then you're probably not going to be able to get through that initial threshold. The last part, when we're talking about like tangible medium, I mean, the copyright laws that were built were primarily built around the idea of like the printing press. And so before, the idea of copying was a very literal, like you had a machine where you would, to copy something, you would have to like, it was a whole big deal. Obviously with the internet, really easy. And if you don't like crypto and NFTs, then the whole right-click, copy, save image as. If you haven't heard of any of that, there's a lot of people who don't like NFTs, and they're like, hey, you said that you have this really special token that nobody else has the rights to, but I can just go on the internet and I can copy this image, and boom, I've got my own copy. So what makes what you have unique? I don't really feel the need to get into too much about NFTs here, but some of the stuff that's digital and whether it meets the fixed or tangible medium terms can be a little bit complicated. So as technology grows, you just have to be aware that the laws are old, and it's going to take lawsuits or legislation to change the laws that we have in place. And so things like streaming on YouTube and Twitch, they are very much pushing the bounds of a lot of our current legal terminology. And we don't really have a lot of litigation in those areas to define bright line rules. So it kind of makes things really messy at times to give bright line legal advice to actual clients. And then just to talk about it, so aside from NFTs, another controversial, but I would say important conversation that comes up with copyright is AI. And so maybe a controversial take, AI is not inherently bad, but there are definitely people who use it in a way that's just not sustainable or good. And so we're having this presentation at the conclusion of like the SAG-AFTRA strikes. And so for the people who haven't been keeping up to date with that, basically writers for films, TV shows, and other types of writers have been trying to protest a lot of big industry leaders who want to use AI to cut out graphic designers, artists, other creators along the way. So their intent is to cut costs. They're not doing it because they want to move the genres or anything forward necessarily. They're literally just doing it for efficiency and money. And so that, I can say, is probably just a bad thing. Using AI as a tool for your own personal efficiency to open the door for creativity's sake, that's something that I don't think is inherently bad. But when you're in a position to, when you've got a lot of money and you have the opportunity to hire people and make a very sustainable path, trying to do this, it's very selfish, I guess is one way to put it. But anyway, we've got some really interesting case law that will talk about how we see AI in the copyright world. And actually one of the first AI cases that came out was from earlier this year. If you've heard of Zarya of the Dawn, that was a comic where the artist actually made part of the images through Midjourney. Just for a quick show of hands, does anybody know about any of that, like Midjourney? Okay, we got a few people that are nodding head. For just a couple of us who don't know, basically Midjourney is a place where you can go on a Discord server, more or less, and you could type in a prompt and say, hey, I would like to see an image of, okay, I like frogs, so I'm gonna pick something that's a little bit more neutral. I wanna see a picture of a frog smiling with teeth. Now that might be a little odd because frogs don't have teeth. You plug it in and you'll get a set of images and you can kind of pick, you'll get 4 images that you can choose from and say like, image number 2, great, love it. Image number 1 through 4, maybe I don't like them. So then I can ask for more results. It sounds great, right? The question is, where does the source material for those 4 images come from? And that is where a lot of the problems with AI in the current form come from. So there are a lot of lawsuits against like Midjourney, ChatGPT, which is OpenAI, and other big companies that have these tools, because what they're doing, I'll just say allegedly, is taking their systems, taking their AI and training it. And so basically, they're going to give a whole bunch of images to their tool, their AI tool. It's going to scan it, and then that way if somebody says, hey, I want this image, but painted like a Monet or a Van Gogh, then it's incorporating those Van Gogh or Monet images, or it'll incorporate photographs of other people's frogs to make whatever your content request is. And so the Copyright Office actually for Zarya of the Dawn said, hey, look, you've got AI that is quote unquote generating this content. And there's this whole piece about whether a human author is required for art to be registrable for copyright. Time after time, the Copyright Office said, yes, you have to be a real human being. You can't be the monkey that took the selfie, where they tried to register that as a copyright. Stephen Thaler is also like a professor. He's tried to register art where he put, this was created by my AI, and he listed his own AI as the author. That has been rejected. And so so we've got, is it a human author? And then you've got, is it a tool, or how are you using the AI? And that is something else that the Copyright Office picked up on quite a bit. And they said, look, you're putting a prompt into the system for Midjourney, but Midjourney is more or less picking from a hat what those images look like. It's not drawing them at your direction or any type of control. It's more of like a filtration system. And so we kind of get into the space where, depending on how much control and how much involvement you have directing the AI, you could potentially be able to use content that's created by AI and have it registered. But what they told both in the case of Zarya Dawn and for Stephen Thaler, where it was appropriate, they said, look, the way that you're using the AI tool is too hands-off. I think that, at least for Zarya Dawn's sake, there was some more Photoshop retouching up and some other efforts that could have made it a little bit more human created to satisfy that requirement, but it's just something else that is currently still in litigation right now. So we'll see where they go, but obviously Zarya Dawn, that's an example where using AI more like a tool rather than trying to say like, hey, instead of hiring artists, I'm just going to, hire an AI bot that's free, or whatever the subscription is, and we're just going to sub a lot of that. That definitely wasn't the case for the artist who made Zarya Dawn. She's an artist. She was able to design everything else. She did like half of the content on her own. All of the pieces that did not have any reference to AI ended up being registered. She just ended up losing the content that was predominantly authored by the AI in Midjourney. So you just have to, if you're thinking about using something like that or using ChatGPT to help write a novel or a story, you're just going to have to keep in mind that it may require a little bit more effort to shape it up. Let's see if there's anything else. Oh yeah, and so because of how the AI tools are sourcing their content, a lot of the big service providers are getting sued because it's really hard to show, hey, this is inspired by this art, and therefore that means that they had to have access to it, until you get into the legal process and you can go through their search history, so to speak, or get those internal emails where they're like, hey, I just ripped like 100 Van Gogh paintings, or I just ripped a whole bunch of Andy Warhol images, so we can use all this, it's totes legit. If you get something like that and you're on the other side of the table, you're having a great day. But that's also usually in the early stages of litigation, not necessarily at a public-facing time. You'll see all of the allegations in a complaint, but that's kind of where we are right now with most of the litigation. It's all in the first stages.
I'm familiar with the lawsuit with Kelly McKernan. She's an artist. She's one of 3 artists that are apparently suing Midjourney, DeviantArt, and I think another company over having, I think 50+ pieces of their artwork is great. McKernan specifically, like it got to the point where like the AI was recognizing her logo as like a part of the art and then putting it in the AI creation.
Yeah, some of the lawsuits out there are really funny, not in like a, actually, yeah, in a haha kind of way, because it's just so bad. There's like a separate, there's a separate way that you can get sued for a form of copyright infringement. And so we have the letter C with the circle around it, and that's just saying, hey, this person is potentially enforcing their copyrights. It doesn't really have a lot of significance today. Like when I get to trademarks, I can kind of talk about the difference there for the symbols, but you used to have the C so you could get your work registered. And so if somebody has those notices in the front of like your textbooks or other places where they say, hey, this is a registered copyright, do not copy it. If you do, it's infringement. We can sue the daylight out of it. So with digital downloads, especially, or with some of the images where they have, I can't remember the word, where they have the transparent like logo that goes over the top. Watermark? Watermark, thank you. Yes. So for like watermarks and for other things, if you have that work registered with the Copyright Office and then somebody like Photoshops that out, that's a separate legal violation. And people were using the AI tools like ChatGPT, some of these other tools that I've talked about, and they would copy the text. So they'd be like, tell me about, I don't know, let's pick a random book. I don't know, just like read me the plot of Spider-Man, or tell me the entire manuscript of the B movie. And so people who are getting that, they're getting also the copyright notices, and then they're deleting it, and then they're using it for their own purposes. And so that's like its own separate, like, not only are you bad in the sense of like copying the content, but also deleting the copyright notices, it's its own problem. So yeah, it get some interesting lawsuits. I mean, part of the reason why this stuff is so frustrating is because you get a lot of really lazy people who are using AI to try to cut corners. And sometimes the people who are lazy are doing it because they're smart and they're trying to find a way to work around. Other times it's because they just don't want to put in the effort. And you can really tell those two parts, you can tell those two groups apart because they're going to have that whole log of emails or something where like, hey, I'm trying to steal this guy's art and this system didn't work. You know, how do I work around it? I mean, the smart people are going to say, hey, look, I would like to license your content and I want to use this tool. Is that okay? There's like two different ways to go about it. And so, yeah, a lot of these artists that are having their art put into these generators, it's really hard right now to litigate it. And so you're seeing a bunch of bigger artists start the process, but hopefully that will open up the conversation to kind of further licensing terms. And I don't know, the internet's just a scary place if you're an artist. It's great for discoverability purposes if you can get it to work, get the algorithms on your side, but at the same time, there are just so many ways that your art can be ripped and re-uploaded on Reddit, on Etsy, everywhere. So it's great, but it's also terrifying.
Red bubbles are pretty good. That's kind of like off.
Yeah.
A little bit.
Yeah, so go ahead.
Question, just from the last slide, for generic class and themes, that seems more straightforward to me, but does not protect ideas. Can you give me an example of an idea that would not?
Okay, yeah. So when we're talking about copyright, I didn't get into all the points here, but one of the examples that I was taught was, let's say I want to write a book about zombies. So zombies as a concept is an idea. It's an undead, a creature that was alive, died, and now they've come back. And at that stage, it's kind of like an idea. If I wanted to talk about a system for reanimating a corpse and making a zombie, then that could be qualified as an idea. That's kind of where we get into patents. And so that's how I'm trying to distinguish what an idea is. It's a very broad level kind of category. Whereas if you say, hey, look, I've got a zombie, it's going to be named Steve. And Steve works at Starbucks, and Steve really just hates AI. Well, now I've got more specific character. And hopefully with more descriptors and things, we're going to get away from, well, if I'm writing about zombies, then there's a lot of stereotypes that zombies eat human flesh or they do other things. So we're going to stay away from those generic areas because those aren't going to be protectable. And we're going to have a more nuanced character that's original. And hopefully our character, Steve, would be eligible for copyright and trademark, depending on all that. But yeah, and then I'll just go ahead and say the last part. So for copyright, we have this idea that you can make a drawing, and if I scribble a little face and I've got it on this piece of paper, technically it's fixed because it's done and it's on this piece of paper. So it's tangible, literally. I could apply for the Copyright Office. Whether that's going to be original or some of those other things, yeah, that's a separate issue. But if somebody took a photo of this and then started using it, then before I could sue them, I have to go to the Copyright Office and file for the registration. So that's just another thing that a lot of people don't necessarily know, but it's very important. If you have your work registered before somebody starts stealing your content, and especially if you can show that, then you're able to get elevated or higher damages from the lawsuit. So that's also really important. I say that knowing that we're talking to a lot of students. And so, if you're a student and you don't have a lot of financial resources, the $45 to $65 per application from the Copyright Office can be a bit much. So, choose your battles is one way to go about it. But if you have something you're going to share on Reddit or somewhere else, then you just might want to go ahead, pay the money, and start the registration process before.
I was at another panel with a lawyer from Maryland, up in Pennsylvania, and he had said, I don't know if this was the same thing, but he had said something about basically taking all of your artwork from your website for the year and putting it into an ebook and then listing the ebook at like really expensive cost and copywriting that, I think is what. And so basically it like creates this little like booklet form, because obviously websites are a little bit more, I feel like, Wild West.
Yeah, I mean, there's a lot of different strategies for ways to protect your content. And by doing something like that, basically you're just going to have like a collective work. And it's one way. As long as you're doing something so that you've got your works included, you're going to be putting yourself in a good position. There are other strategies depending on how you use your website. If you just say, hey, look, I'm only going to do this for my published content, then maybe you just got serials like for your, like if you're doing comics or things like that, maybe you already have those as separate images and you would, in theory, file those as one application or, however it makes sense. But yeah, there are a lot of different strategies for kind of making like if you do a lot of photographs, if you're a photographer, then they have group filings. And so that would be another alternative. There aren't always group registration options. It just depends on the media though. So yeah, it's really nice. Definitely recommend anybody trying to do that where you can. And then this is just a slide being like, hey, look, copyright, it's all of these different types of things: painting, sculpture, art, music. Got some magazines kind of looking at comics in the traditional format, webtoons, same thing. I'll just go over some of the rights here really quickly. Reproduction, that is just literal copying. And so copy image as, like being able to use that function is a form of reproduction. We used to have, like I said, the printing presses where you would have the characters all out and you would have to like construct your press to be able to copy the article. It's a lot easier to do that now. Derivative works, that's where everything gets a little bit more complicated. This is where everybody says, well, what if I change the artwork a little bit? Or how much do I need to change Mickey Mouse until I can make my own mouse-like character? You start out as a derivative work, which means that you could get sued if you don't get permission to do it. And then depending on any type of case law or anything else, you might be able to get beyond that. But I always just like to say you start out with a derivative work, and then depending on what else happens, you might end up in your own original work. Distribution, just think about that like Amazon, like the delivery trucks that go around. That's all we're really talking about. If you wanted to hire somebody to make the copies and then you want to hire Amazon or a fulfillment company to send it out, you have that separate right. So if somebody else tries to, if you hire the company just to print and then they end up trying to hire their own distributor and they haven't gotten that license cleared from you, then you could sue them. Public performance, typically just talking about music. Public display, think about art in a gallery, like I'm gonna call it like Artist Alley upstairs. Displaying your artwork on your tables and things, that's kind of what that would be. Fair use is not a legal right, it's a defense. And so what that means is when I say, hey, I'm gonna copy somebody's work, but it's fair use, then what I'm admitting is I'm copying their work, and if they sue me, then at that point, I better hope the judge agrees with me. Because if they don't, I've already admitted to copying. That's not a great spot for you to be. And because it's gonna come down to the case situation, we've got 4 factors that look into all that stuff, but just know that filing, like preparing your work, that's a right to have that work protected, versus this, it's a defense. So you don't just automatically get it. You have to say, hey, look, I already admit that I copied the creator's work, and I'm gonna accept the liability there if I get sued and lose. Some other just like minor comments. Public domain, just because it's on the internet or just because somebody says it's public domain doesn't mean it is. So to figure out whether something is public domain, you have to go through this timetable, and it was really complicated for me to learn in law school. And let's just say if the work was from the 60s to now, that it's still a gray area. If you're talking about content that was created from, let's say, 1933 and back, it's most likely safe. But if somebody else, like, let's say there's a composer or like a songwriter who took classical music. If they took that music and then they changed the tempo or they changed something else, well, they're adding their own element to it. That's a derivative work. And so if you perform that or you do something, now their version is like not from the 16th century or whenever the original content was from. You gotta be very careful about it. And that's more or less what we say about the internet piece as well. Name, image, and likeness rights, it's not copyrights, it's something that is going to be state law specific. There's no federal right to name, image, and likeness, but you just got to be careful on using brands or even silhouettes. People will try to use silhouettes.
So I'm in a student publication, and a way that we kind of go around fair use is when we don't know something's fair use, we usually make a replication of it in one of our styles. Would that be technically copyright?
So we're walking into legal advice territory, right?
Okay.
What I can say without telling you what you should or shouldn't
Yeah.
do, right, is that if you don't know, then, I mean, obviously, do as much diligence as you can.
Mhm.
Sometimes that is just looking into, hey, this came from some obscure artist who is no longer making art, but I'm not sure if they would do it. You just gotta follow the lead.
Yeah.
And what I would normally tell people in this situation is if you don't know, then your best bet is to avoid the content. Otherwise, we're in this territory of like, well, it's on the internet, they look like they're an obscure artist, and so I'm gonna make a business decision to take on the risk.
Mhm.
So, I mean, if I were going to give you advice, then we could go through and we could do a risk analysis, but yeah.
And what do you say about say someone heavily references say a photograph or something? Would that be technically under the copyright of the photographer? If it's basically a trace over of an exact photograph, is that technically what's the realm of that?
So that is where we start with the derivative work,
Yeah.
and then depending on what happens from there, is the arrangement of the photograph the copyrightable piece? Because this is where we can kind of get into a lot of nuanced language. If you don't follow, feel free to say something. But let's say I take a photograph of a frog. Frogs, in and of themselves, are not protectable. But if I take a picture of a frog that's hanging from a leaf or a branch or something, and there's a cool light effect that makes it glisten,
Mhm.
then what I have as a copyright is that specific instance. And so then you have to get into the whole realm of, it's the frog in this particular lighting with its body in a particular arrangement. I compose my shot. And so that's the nuance. If you are in a position to say, hey, look, I just have some item that is more generic, then we can put it in that hey, this is a sans affaire. The French word for just this is the background, and it's fine to use types of background content where you're not, frankly, when you're not dealing with one of the big brands. But it's all going to come down to how you're copying and what you're copying. Trademarks. So this is where we talk more about logos. I'm going to pick up speed and probably steam through this a little bit more, but that's okay. So yeah, basically branding is really important. You're able to register things with the with the trademark office. It's separate from the copyright office. The circle R, if you've seen that, it actually matters a lot more for trademark purposes, just because that means that you actually went to the trademark office and got a registration in the United States. If you see the TM with the circle, it doesn't really matter. You don't have to have anything. I could do it right now for this presentation, and everybody might be a little confused, might be impressed, but it doesn't mean anything. And so with trademark infringement, the legal terminology that we're looking for copyright is substantial similarity, which is kind of how we get into how similar are things. Trademark, we're trying to figure out, would a consumer confuse your product with somebody else's? If the answer is yes, then there's a likelihood of confusion. There are different terminologies to figure out how strong your trademark is. I might skip through that for now, but basically if you sell apples and your name is going to be so-and-so Apple Company, then it's not a really strong mark. But in the context of computers, if Apple is your brand, it's unrelated. And so for people to say, hey, I'm going to buy an Apple MacBook or whatever, and know what you're talking about, you probably had to market a lot to get that out there. And so for trademark purposes, good on you for getting your name out there and building a brand. And you're going to have extra protection. And so that's where we're looking at trademarks, try to distinguish yourself. There was actually a lawsuit about these spider logos. And so we've got the Spider-Man logo, we've got the University of Richmond logo, and then we've got another image here. And basically, University of Richmond got sued for trademark infringement at one point from Spider-Man. And so it wasn't a great time. One of my friends who's a vet was like, you guys don't even have a spider as your image, like logo? That's actually a tick. And so it's kind of a funny thing, but that was how the University of Richmond changed their logo so that they wouldn't get yelled at by Marvel or now Disney. So, and then there are just a lot of reasons why as you develop as a creator or as your friends and family members do, that you should think about forming a kind of business structure. Limited liability companies cost $100 one time to form in Virginia. And so what I'd say there is it's worth it once you start to grow. Sooner is better than later. If you get sued, it's nice to have a bucket that you can, in theory, set your artwork and copyrights and trademarks and things off to the side. Like if I get hit in a car accident, then usually if I don't have much money, the person who I hit would say, hey, look, I want you gotta like liquidate your stuff. I don't care. Sell your house or do something so that you can pay for my car or pay for, whatever other damages I have. And so we have limited liability in a sense where you might be able to differentiate yourself as a person from your business entity. And so that's why they call it limited liability, because you're protecting yourself in a limited capacity. You can't just like do crimes and be like, I have an LLC, but you can definitely split yourself up. As long as you have a separate bank account, you treat your business as a separate entity, then you're going to be putting yourself in a better position. There's some tax considerations. I can get through some basic tax advice, but I won't do it here. Everything else, go to a CPA, go to a financial advisor, and they will probably help you decide when they plus an attorney like myself will be able to kind of decide, is it a good time to form an LLC or to create a corporation? Make contracts, have things in writing, or like if you're going to talk about artwork and you do it orally, you're going to be setting yourself up for a rough time, because that's where I guess my mentor and his. Okay, well, one of the things that I'm going to borrow from my mentor is contracts save friendships. So if you're going to hire somebody to make just one scene in a comic series, well, technically they created it. We talked about how once you create the artwork, it's fixed. They have the rights to it. If you don't have a contract that transfers all the rights to you, then technically you owe them, and they own that part of it. So unless you have something clear and organized in writing, then you're going to be setting yourself up for potential challenges down the road, lawsuits. Let's say you get big, they're going to sue you because they're going to want a piece of that pie. And if you don't have some arrangement in place before, then they have every right to get whatever pennies, they deserve.
Yeah, so on that, I help run like a networking group, and every year we put out an anthology sort of thing. Not sort of thing, it's an anthology. But how far do like agreements over text that like are in writing but aren't necessarily contract? How far
That can
do those
work.
go? That still works?
They can.
Okay.
Does that count as a contract, like any email?
Yeah.
Like, okay.
So, one of the first contracts that came up with Twitch was actually like for a partner, somebody who became a partner on the program, like an affiliate, special privileges, all that stuff from Twitch. It was actually just an email. And so if you've got people who say, hey, I will do this if you do this, and then they make a payment or they do other things, based on that email, you've got a contract.
Yeah.
The scope of it, it's gonna come down to your state law and your courts and things, but everything else is gonna be very important. So, also whether you're an employee or a contractor is gonna matter a lot for artists. If you're an employee, the art that you make for your employer, automatically their stuff. Contractors, usually there's a work made for hire provision which says, hey, I've hired you to do it, now the rights are gonna be mine. Just be aware of those types of provisions, know whether you're a contractor or an employee, and you can go from there.
You're gonna get there.
Yeah, there was also a lawsuit where they filed a complaint, and I'm wrapping up here. They actually drew a comic for the complaint because this one group really hated Crown Plaza Hotel. They had guests that were throwing stuff out of the hotel, and it was like crashing onto this comic store. So they hired people, and their complaint is actually, like, this is part of a legally not enforceable, but a complaint that went to the court. That was kind of cool. This is a book that I met Joe Sergi at one of these presentations before, and just a great intro to kind of the history of law when it comes to art for comics. But if anybody has any other questions, I know I need to get out of here, but feel free, I'll stick around outside if anybody wants to chat. I've got my contact information if you want to take a photo. You can email me. I've got a Twitch channel where I actually do stream. I do like some gameplay stuff, and then I chat for a little bit. So I'm happy to have like a more of an office hour type space on the Twitch channel. It's twitch.tv/teamgap. So, you gotta have our law references and make puns to enjoy life. But you can also, I have my Hive handle, but doesn't really do much now. So if you want to connect on Discord, I have a server for the community that I'm growing with Twitch. And so we can stay in touch there. Feel free to reach out after. All right.